Judicial Committee of the Privy Council has unanimously concluded that the appeals should be allowed and the appellant's convictions should be quashed.
Adidja Palmer, alias Vybz Kartel's conviction was quashed by the UK Privy Council at 11 a.m. Eastern Standard Time, which takes effect immediately.
One of the East dancehall, Lincoln Terrage Records. One of the Takai Tony dancehall, Lincoln Terrage Records. Your entourage, the meat you eat from money, your ruggedness.
Bless up, and welcome back to Entourage Records. You're new via here, please consider subscribing, turn on your post notification bell so whenever I make a new upload, you can be the first to be notified. The UK Privy Council Court of Appeal have handed down its verdict, and according to what I told you guys previously, that this is something similarly that will happen based on these grounds, and that's why the decision came back so early rather than an estimated 12 or so weeks, which was first said after the appeal was heard. If you are the subscribers, I want to listen carefully. I want to leave a thought, I want to comment in the comment section, and then we are going to discuss that one here.
Judgment in the matter of Sean Campbell, Adidja Palmer, Kahira Jones, and Andre St. John against the King.
On the 13th of March 2014, following a 64-day jury trial in the Home Circuit Court in Kingston, Jamaica, the appellants, Sean Campbell, Adidja Palmer, Kahira Jones, and Andre St. John, were convicted of the murder of Clive Lizard Williams, to whom I shall refer as the deceased. At trial, the prosecution case was that the deceased and another man, Lema Chow, had been given two unlicensed firearms belonging to Palmer for safekeeping. On the 16th of August 2011, Campbell summoned Chow and the deceased to Palmer's house after they had failed to comply with Palmer's deadline for returning the weapons. The prosecution alleged that they were met on arrival by Palmer, Jones, and St. John, and that Chow and the deceased were both attacked, after which Chow saw the deceased lying motionless on the ground with Jones bending over him. Chow escaped, but the deceased was never seen again. Police attended Palmer's house on the 22nd of August 2011. They noticed the house smelled of disinfectant. On the 25th of August, they cordoned off the perimeter wall, treating the premises as a crime scene. When they returned on the 27th of August, they found that the entire interior of the house had been destroyed by fire. On the 29th of August, police forensics reported a foul odour emanating from the living room. On a further visit on the 30th of September, it was discovered that the rear of the house had been demolished. Police dug at the premises but did not find a body. The police seized the mobile phones of Palmer and St. John. Text messages, voice notes, and a video from those phones were put in evidence at the trial. The prosecution also relied on telecommunications data which the police had obtained from Digicel, a communications provider. The prosecution case was that the mobile phone evidence and telecommunications data, taken as a whole with Chow's evidence, proved the fact of the killing, the reason for the killing, the method of disposal of the deceased's body, and the identity of at least one of the killers, namely Palmer. The four appellants each denied murdering the deceased. At trial, the appellants objected to the telecommunications data being admitted as evidence. They argued that the data was inadmissible because it had been obtained in breach of the Interception of Communications Act and the fundamental right to the protection of privacy of communications guaranteed by the Charter of Fundamental Rights and Freedoms contained in the Jamaican Constitution. The judge admitted the evidence. He ruled that the data could be relied upon by the prosecution even if it had been obtained in breach of the Charter or the Interception of Communications Act. Over the course of a 64-day trial, there occurred a series of incidents involving the jury. The jury was reduced to 11 members after a juror was discharged almost 8 weeks into the trial. On the final day of the trial, it was brought to the judge's attention that a member of the jury, who will be referred to as Juror X, had attempted to bribe other members of the jury. The judge questioned the jury forewoman, who stated that Juror X had offered bribes to each of the other jurors to acquit the appellants. The judge asked counsel for the prosecution and the defense if the trial could continue. It would not have been possible only to discharge Juror X, because under the Jury Act, a trial for murder cannot continue with fewer than 11 jurors. The judge decided to proceed with his summing up and gave a direction to the jury, reminding them of their function. The jury retired to consider its verdict at 3:42 p.m. The jury returned at 6:08 p.m. and by a majority of 10-1 convicted all 4 appellants of the deceased's murder. A 5th defendant was unanimously acquitted. Juror X was immediately arrested and was later convicted of attempting to pervert the course of justice. There was no evidence to connect his activities with the appellants. The appellants appealed against their conviction to the Court of Appeal of Jamaica, which dismissed their appeals. The Court of Appeal granted permission to appeal to the Judicial Committee of the Privy Council on 3 grounds, which were, first, that the trial judge failed properly to inquire into allegations of juror misconduct. Secondly, that the trial judge departed from standard practice in inviting the jury to retire to consider their verdict so late in the day, putting undue pressure on them to reach a verdict. And thirdly, that the trial judge erred in admitting the telecommunications data because it had been obtained in breach of the Interception of Communications Act and the Charter. The Judicial Committee of the Privy Council has unanimously concluded that the appeals should be allowed and the appellant's convictions should be quashed on the ground of juror misconduct, and that the case should be remitted to the Court of Appeal of Jamaica to decide whether to order a retrial of the appellants for the murder of Clive Williams. The Board has considerable sympathy with the dilemma faced by the trial judge on the final day of a long and complex trial. Following the allegations of bribery, he had either to continue with the 11 remaining jurors or to discharge the jury. Despite this, the Board considers that the approach taken by the judge was a material irregularity in the course of the trial, which makes it necessary to quash the convictions. This is for 3 reasons. First, the direction to the jury on the final day was inadequate to save the situation. The judge simply reminded the jury that they had sworn or affirmed that they would return verdicts in accordance with the evidence they had heard in court. The judge did not refer to the alleged bribery, of which, if the allegations were true, the jurors were already aware. Secondly, the trial continued with the allegedly corrupt juror serving as one of its 11 members. In the Board's view, there should have been no question of allowing Juror X to continue to serve on the jury. Allowing Juror X to remain on the jury is fatal to the safety of the convictions which followed. It was an infringement of the appellant's fundamental right to a fair hearing under the Jamaican Constitution. Thirdly, the judge should have considered that the remaining jurors might have become, consciously or unconsciously, prejudiced for or against one or more as a result of Juror X's behavior. For example, there was a danger that the attempted bribe could have made the other jurors overcompensate, consciously or unconsciously, if they assumed that the offer must have come from one of the appellants, and that therefore they must be guilty. The judge took no account of this risk. The Board is very mindful of the serious consequences which may flow from having to discharge a jury shortly before the end of a long and complex criminal trial. It is also very conscious of the danger of deliberate attempts to derail criminal trials by engineering situations in which it is necessary to discharge the jury. In England and Wales, there is legislation which allows a judge in certain situations to discharge a jury because of jury tampering and to continue the trial by judge alone. There is no such legislation in Jamaica. It follows that there will be occasions where, as in this case, a court will have no alternative but to discharge a jury and end the trial in order to protect the integrity of the system of trial by jury. In view of its conclusion on the issue of juror misconduct, the Board holds that it is not necessary to express a concluded view on the other two grounds of appeal. For these reasons, the appellant's appeals should be allowed. The court is now adjourned.
So viewers and subscribers, this is the court. Not the court of public opinion, but the court. I'm going to tell you all the time about legalities. And this is why the Privy Council, they had to come back with a decision like this. We're not talking about what actually happened, what really happened. Anytime you go to court, Vybz Kartel and his co-accused didn't have to prove anything. It was the onus upon the courts to prove them guilty or not. And as we say, the prosecutorial team and the judge, the whole of them batch the case. I say it in my previous vlog, right? I said them batch the case. And them batch the case because them they desperate. They were too desperate because first and foremost, from the moment you start break constitutional law, that's where you get knocked. And the next thing, how can a juror who try to bribe the other jurors still on the case? I mean, yes, if he get kicked off, the case would have to start from scratch. But that's what should happen. And then we would not be talking about this right now because the juror should not be on this case. And because it's a high-profile case and the judge so much wanted to be on this case, the conviction quashed. It cut and dry, conviction quashed. So, me no want nobody tell me say, him guilty, in a proven in the court of law. Or the law, them have a proof it in the court of law. As me say, the only thing they had going for them at the time was chow, the witness chow. But because the defendant, lawyers had questioned chow and asked him if he had seen Lizard dead. And he couldn't say yes nor no. But the only thing that was going for the case was chow. If this case by the trial judge was quashed from then and restarted, it's just because he would not be the judge for the next case, we would not be having this conversation right now. If Paula Llewellyn and them didn't enter the phone evidence because they rely on the phone evidence, we would not be having this discussion right now. And as I say, this will be up to the Attorney General because based on those are the strength of the case. How will they try over this case? Me tell you from the previous vlog, them batch the case. Them batch the case. So we can't say Kartel guilty if in a proof in a court of public opinion. We can't say, yes, him when the lizard body can be found. So him responsible. But one of the only things that can come out of this case, they have a civil lawsuit if Lizard and his family want to have a civil lawsuit for a whole heap of money. It's not hard. It's very easy. I remember me mentioned O.J. Simpson case. Similarity. And this of the similarity in terms of O.J. wasn't found guilty. He was found not guilty. So he did not appeal. The difference with this was Kartel was found guilty. He appealed. Him when he appealed up to the Privy Council. But at the same time, the Privy Council sent it back to the Supreme Court for them to make a decision. And from right here, as I say, he will have to get some kind of ban because him did it too long. Them can't hold him for something when they're guilty of what them say basically conviction quash. So them hands tied right now. And the case costs one whole heap of money if you try. And that Mr. Digger day, right? So who will look for trying this case again without new evidence? It makes zero sense. The man then basically can pack up them things and look for come out. But it doesn't mean that they cannot retry this case. They have to have new evidence because what they have now is just pure circumstantial and it will not fly. If you are not subscribers, let me know your honest thoughts and opinion in the comment section. Do you think the justice system is broken? Do you think the prosecutor messed up the case and they had rushed to judgment, and if they handled it better, we would not be having this discussion? Or do you think Kartel is not guilty, cut and dry? Please leave your thoughts, your comment in the comment section so we can talk about it. We've come to have another video. Thanks for watching. Please like, share, and subscribe to the channel, those who have done so as yet. Also, please turn on your post notification bell so whenever I make a new upload, you can be the first to be notified. Peace out, bless up. I'll definitely catch you in the next one.